Good afternoon, happy Veterans Day, and welcome to the University of Georgia School of Law and the 2024 Judge Horace J. Johnson, Jr. Lecture on Race, Law, and Policy. I'm Bo Rutledge, the Dean of the Law School, and on behalf of myself and my colleague Matt Auer, the Dean of the School of Public and International Affairs, we're pleased to welcome you to this annual lecture co-sponsored by our two schools and made possible by an anonymous benefactor. At the law school, we are committed to redefining what it means to be a great national public institution, one that provides a world-class, hands-on, purpose-driven educational experience with a pioneering commitment to accessibility and affordability. Our mission is defined by three words: prepare, connect, lead. Today's lecture advances that mission and honors a late alumnus and pioneering jurist. Judge Horace Johnson was a pioneer throughout his life. He was one of 5 children who helped to desegregate the Newton County, Georgia schools in the 1960s. 2 decades later, he graduated from this law school, and after a brief stint working in Atlanta, became the first Black attorney to practice in his home county, and later the first Black Superior Court judge in the Alcovy Judicial Circuit. He remained in that role until his untimely death from COVID-19 in July 2020. Honoring that legacy, today's talk, entitled Judicial Courage, will feature 2 respected federal jurists who explore how individual bravery and the resolve of the judiciary were pivotal in achieving monumental victories in the field of civil rights. It is inspired by Judge Gergel's book, Unexampled Courage. Fitting for a day where we honor our nation's veterans, Judge Gergel will explore the judiciary's response to demands for equal treatment from Black veterans returning from war, highlighting its profound influence on civil rights law. His colleague, Judge Michelle Childs, will share inspiring stories of federal judges who helped to advance civil rights by consistently upholding the rule of law in the face of threats and violence. Before turning the program over to them, indulge me a brief biographical sketch on each. Judge Richard Gergel is a native of Columbia, South Carolina, and the grandson of Russian and Polish Jewish immigrants. He earned both his bachelor's and law degrees from Duke University and practiced for 30 years, specializing in complex civil litigation before being sworn in as a United States District Judge for the District of South Carolina. He's handled numerous significant cases, including the 2017 trial of Dylan Roof. Interestingly, Judge Gergel now presides in the very same federal courthouse where his maternal grandparents were naturalized as American citizens, a fact he shares in the naturalization ceremonies over which he presides today. He's the author of numerous articles and books with a focus on American legal history, including the one that anchors today's talk. Judge Michelle Childs was appointed to the U.S. Court of Appeals for the District of Columbia Circuit in 2022. She began her judicial service as a South Carolina State Circuit Court judge, including appointments as the Chief Administrative Judge for General Sessions and the Chief Administrative Judge for the state's Business Court. From 2010 to 2022, she too served as a U.S. District Court judge for the District of South Carolina. She earned her undergraduate degree from the University of South Florida, law degree from the University of South Carolina, master in personnel and employee relations from the University of South Carolina, and master in judicial studies from Duke University. After law school, she joined the firm Nexon Pruitt, eventually rising to partner. She later worked as a deputy director for the South Carolina Department of Labor, Licensing and Regulation, and later becoming a commissioner in the South Carolina Workers' Compensation Commission. Judge Childs presently serves as the president of the Federal Judges Association. We could not be more honored to have 2 incredibly accomplished, distinct jurists, and I hope all of you will join me today in welcoming the Honorable Judge Richard Gergel and Michelle Childs.
Good afternoon, and thank you, Dean Rutledge and others, for the very fine invitation to be here today, and of course, that wonderful introduction. It is such a great privilege to be part of the Judge Horace J. Johnson Jr. Lecture at the University of Georgia. This is a place with profound connections to the struggles and the triumphs of the civil rights movement. And we owe so much debt of gratitude to Judge Johnson because of his compassion and legacy for the civil rights struggle. Now, before I delve into the theme of today's lecture on judicial courage, I wanted to take a moment and recognize today as Veterans Day. The history of this day goes back to the end of World War I, when it was originally established as Armistice Day to commemorate the signing of armistice on November 11, 1978. In 1954, after World War II and the Korean War, Congress amended the law transforming Armistice Day to Veterans Day. Later in the same year, President Eisenhower stated in the first Veterans Day proclamation that on every November 11, let us solemnly remember the sacrifices of all those who fought so valiantly on the sea, in the air, and on the foreign shores, and to preserve our heritage of freedom. And let us recommiserate ourselves to ask of promoting and enduring peace so that their efforts shall not be in vain. Today, Veterans Day is still recognized as a federal law at a time to reflect and honor the service and sacrifice of those who defended this country. That said, honoring our veterans goes towards our memories for today and these key words for our ceremony. Veterans Day underscores this commitment to protect veterans' rights under the rule of law. The GI Bill has now been in place and it offers educational training and benefits to veterans and their families. The Veterans Claims Assistance Act establishes the duty of the Department of Veteran Affairs to assist veterans to obtain their benefits. The Uniformed Services Employment and Reemployment Rights Act protects veterans' ability to obtain employment after they return to civilian life. All of these laws provide a foundation for veterans' rights in the courts, and they are tasked with upholding rights guaranteed under the law. I come from the United States Court of Appeals for the District of Columbia Circuit, and just last year, the DC Circuit clarified the standards governing disability determinations for veterans, helping to ensure that all veterans will be appropriately rated and fairly compensated for the injuries they endure while serving in the armed forces. So it's very fitting that we will have this occasion that will be a book by my colleague, Richard Gergel, Unexampled Courage, in playing that pivotal role. So in honor of today's theme, Judicial Courage, I want to tell you a few stories about judges who helped to desegregate the South, adhering to the principle, separate but equal was never constitutional. These judges faced immense personal risk, but remained steadfast to their duty to uphold the law. Because of their courage, the rule of law prevailed during a time of deep unrest and change in our nation. Beginning with a South Carolina judge, Julius Waring of South Carolina, he stands out as one of the earliest judicial figures in this fight, whose courage was evident before Brown. Again, my dear friend and colleague Richard Gergel will define that in his excellent book, Unexampled Courage. And despite the heritage as a son of a Confederate soldier, Judge Waring made a courageous turn toward civil rights. Following his appointment by President Roosevelt in 1947, Judge Waring ruled that South Carolina's Democratic Party could not exclude Black voters. The response was vicious. Crosses were burned in his yard, rocks were thrown through his windows, and his name was synonymous with betrayal in his home state. One magazine even labeled him as the lonesomest man in town. Yet, Judge Waring persisted. In 1951, before Brown, he issued a powerful dissent in Briggs v. Elliott, one of the companion cases of Brown v. Board of Education, a case that challenged school desegregation. He wrote, "Segregation is per se inequality." His words would later influence the United States Supreme Court majority opinion in Brown v. Board of Education, but his bravery came at a personal cost. He was ostracized, and eventually driven out of South Carolina by the very people he served. In 1954, the Brown decision led to an increase in civil unrest in states operating segregated schools and colleges. Amidst the tension came Judge Frank Johnson Jr. Soon after the Brown decision in 1954, President Eisenhower appointed Judge Johnson to the United States District Court for the Middle District of Alabama. On the bench, Judge Johnson maintained his independence and judicial philosophy of providing a voice for the voiceless. In 1956, Judge Johnson ordered the desegregation of public buses in Montgomery, spurring an avalanche of constant political attacks. Judge Johnson believed the city's bus desegregation violated the 14th Amendment, extending the reasoning of Brown to public accommodations. His service continued in upholding voting rights for Tuskegee, Alabama, ordering the integration of public schools in Macon, Alabama, and mandating voter registration for eligible voters in Selma, Alabama. These rulings came at unfathomable cost today. In the 1960s, private critics burned a cross on his lawn, burned his mother's house and bombed it, and delivered several death threats, prompting around-the-clock protection from federal marshals. Public critics like Governor Wallace muzzled Judge and mocked Judge Johnson, defied his court orders to turn over documents, sent state troopers to prevent desegregated schools from opening, and called him a hypocrite. Despite these attacks against him and his family, Judge Johnson remained unwavering in his commitment to uphold the law. In a 1977 lecture delivered at the University of Georgia Law School, Judge Johnson, unbothered, said, "Courts do not relish making such hard decisions and certainly do not encourage litigation on social or political problems. But, I repeat, the federal judiciary in this country has the paramount and the continuing duty to uphold the law." And then we turn to the Fifth Circuit Four, Judge Richard Reeves, Chief Judge Elbert Tuttle, Judge John Minor Wisdom, and Judge John Robert Brown. These four judges all came from drastically different backgrounds, but they all united against civil rights laws at a time when the South resisted implementing Brown's desegregation order. Rather than merely challenging de jure segregation, the Fifth Circuit Four helped break de jure barriers to African Americans. In Jackson v. Rhoden, a Fifth Circuit panel, including Judge Reeves and Judge Brown, ruled against the Mansfield Independent School District's attempt to circumvent integration by busing Black students to a distant, segregated school. Similarly, in another case involving the University of Mississippi, Judge Reeves, Tuttle, and Wisdom found that an alumni recommendation policy intended to exclude Black applicants was a patently discriminatory device. Because of their push to desegregate the South, the Fifth Circuit Four made many enemies in their communities. Judge Tuttle was bombarded with angry calls so often, even late at night, that he eventually disconnected his phone line. Judge Reeves faced personal attacks, including desecration of his son's grave by the Ku Klux Klan, while Judge Wisdom's dogs were poisoned. Despite this backlash, they held steadfast to their judicial principles and played a critical legal role to breaking barriers in the South. Finally, I would be remiss if I didn't mention my mentor, Judge Matthew Perry. He was appointed to the District of South Carolina in 1979, making history as the first Black federal judge for our state and also the first Black federal judge from the Deep South. Before he was appointed to the federal bench in 1976, he was a passionate civil rights lawyer and a champion for the underserved and underprivileged. Despite himself being denied equal access to courtrooms, through his legal advocacy, Perry fought for social justice affecting basic human and civil rights, racial injustices, and equal opportunity. Among his most notable cases as an attorney, he integrated Clemson University, as well as the University of South Carolina and other public institutions. And when asked as a young lawyer, facing all of this hostility regarding civil rights, how do you respond to this? He said, I do not conform myself to their conduct or their approaches. Most of what I saw, I was able to deal with in my own terms, armed with the Constitution. So although endearingly referred to as Thurgood Marshall of the South, Judge Perry also received these personal threats to his livelihood. Critics also burned a cross in his yard, which Judge Perry described, it's just the spirit of the times. He too held to his constitutional oath to do equal justice under law. And one thing that Judge Perry had to endure is that South Carolina, and this is important for you law students, used to have a diploma privilege. All you had to do was graduate from that law school and you would be barred. Well, the year that Judge Perry graduated is when they instituted the bar exam. So he says you can thank him for that. Indeed, these are courageous, unsung lives in many instances. And Judge Horace Johnson fits that bill as well because he was named as a judge who embodied that spirit and courage in his commitment to justice. And finally, I just want to say, I think back about our oath that we all took as judges, and particularly many of us who have gone to advance to other courts, you were constantly reminded of that awesome commitment while you're repeating the oath. It is not just some commitment of lofty words. It is a commitment for primarily three reasons. First, it reminds all judges that their principal responsibility is to execute their assigned duties without fear or favor to the best of their ability. Second, the oath emphasizes that judges do not swear allegiance to politicians, but to the U.S. Constitution. Finally, it bonds all judges to unity and allegiance to the principles of equality and justice for all. So all of these unsung heroes took a familiar oath, and sometimes multiple times. It's a model of courage, continuing for decades, strengthening this nation. And the personal costs were great, but the benefits to the country were even greater. So I hope for all of you that their courage, their competence, and their independence and the rule of law should never, ever bend to fear or favor, and it will continue to teach all of us a lesson about the heroes of justice. Thank you.
Well, thank you for greeting Judge Childs and myself. Judge Childs, you know, I'm also thinking at the University of Georgia, we ought to honor Judge Boodle, who he was the judge who desegregated this university and suffered unmitigated grievance himself a little bit later time than the folks in your talk as well. Judge Childs gave a variation of this talk at the Virginia and Clifford Durr lecture in Montgomery, 2 years ago or so? It was an incredible lecture, and I'm glad y'all got a little flavor of that. You know, all this talk about burning crosses, I remember Thurgood Marshall once said, you know, with all these boys burning crosses, they're not going to have any firewood in the winter. In January 1943, weeks after the entry of World War I, Judge J. Wadis Waring, let me make sure I know how to do this, yes, was sworn in as a United States District Judge. This is right after Pearl Harbor. No one present at that installation, including Judge Waring himself, ever imagined that one day he would issue some of the most significant civil rights decisions of his era, including his visionary 1951 dissent in Briggs versus Elliott, which would become the model for Brown versus Board of Education 3 years later. Judge Waring was a native of Charleston, and his family first settled in the Charleston area in the 1690s. multiple generations of his family were slaveholders. And his father was a Confederate veteran. When he assumed his position as a United States District Judge in Charleston, there was not the slightest suggestion that he questioned the racial status quo of the day. But the truth was, in the early 1940s, civil rights cases were not prominent on the federal docket. That would come mostly in a post-World War II era. In November 1946, Judge Waring presided over an unusual case for the times. The prosecution by the United States Department of Justice of the police chief of Batesburg, South Carolina, for the deprivation of the civil rights of a returning African-American veteran, Sergeant Isaac Woodard. Sergeant Woodard was a battlefield-decorated soldier who was arrested on the day of his discharge from the military while still in his dress uniform after he spoke back to a white bus driver who was transporting him home. Sergeant Woodard was wearing his dress uniform with sergeant stripes on his shoulders and battlefield decorations on his chest. While he was in police custody, basically for talking back to a white bus driver who had spoken disrespectfully to him, Woodard was viciously beaten, ultimately driving the end of the officer's blackjack into each of Sergeant Woodard's eyes, irreversibly blinding him. That image was a very famous image of the era. Civil rights leaders were outraged with the treatment of Judge Waring and other returning veterans, many of whom suffered other acts of violence, mostly in the South, including several racially inspired murders of returning veterans. No state prosecuted any of the perpetrators of these acts. Civil rights leaders met with President Harry Truman in the White House on September 1946 and shared with him the story of the blinding of Isaac Woodard. He had actually been told that the effort initially was to try to persuade him to call Congress back into session to make lynching a federal crime. In that era, that was not going to pass Congress. But when, and Truman had been advised by his staff, there's nothing as a practical matter you can do as president to deal with these acts of violence in the South. But when President Truman the story of the blinding of Isaac Woodard was shared with him, the idea of a battlefield decorated soldier on his day of returning from fighting bravely for American liberty was beaten and blinded while in his uniform, that was beyond the pale. And at that time, President Truman announced at this meeting, we got to do something about this. And the next day he wrote his Attorney General, Tom Clark, and told him the story of the blinding of Isaac Woodard. And 3 days later, the Justice Department undertook then an unprecedented act of prosecuting the white police officer for the beating and blinding of Isaac Woodard. Judge Waring was assigned the case. He was initially skeptical. Why was the federal government prosecuting a local police officer? But his doubts were erased when he heard the testimony of the blinded soldier who detailed his vicious beating at the hands of the police chief. An all-white, and my wife likes to point out, all-male jury acquitted the police officer, obviously culpable police officer, in 28 minutes. As the police chief's supporters cheered that verdict, few noticed that Judge Waring's wife, Elizabeth, who had attended the trial, left the back of the courtroom in tears. Both Judge Waring and his wife were traumatized by the brutality of Sergeant Woodard's blinding and the failure of the jury to hold the officer accountable. Judge Waring would later describe the trial as his personal baptism of fire in his Michigan-born wife's baptism in racial prejudice. The Warings returned home after the trial. The trial of the police officer was in Columbia. He presided in Charleston. The Warings returned home and wanted to learn more about race and justice, subjects they had really never given much thought to. But there was no space in white Charleston of that era to have an honest discussion about race. They began conducting their own private self-study on issues of race and the rule of law. And they read together cutting-edge books on the emerging issues relating to civil rights. One commentator referred to it as they were holding their own private seminar on race and justice. Each night, Elizabeth would read out loud a chapter from one of the books, allowing the judge to rest his eyes after a day of performing his judicial duties. Afterwards, the couple would drive around Charleston, a favorite pastime, and discuss what they had just read. Judge Waring was assigned in 1947 a major civil rights case, Elmore versus Rice, which involved a challenge by George Elmore, an African-American businessman who sought to vote in the South Carolina Democratic Party's all-white primary. The United States Supreme Court had ruled that white primaries were unconstitutional in a 1944 decision, Smith versus Allwright. But South Carolina continued to maintain its white-only primary. Judge Waring advised Elizabeth the day he was assigned the case. He came home and said, Elizabeth, up to this point, our changing and thinking has been a private matter. But if I rule for the plaintiff, our lives will never be the same. By this point, Elizabeth was a convert to the cause, and she said, I'm with you from start to finish. Judge Waring would later describe in an oral history after his retirement that here's how he viewed his choices. Quote, to be entirely governed by the doctrine of white supremacy, or to be a federal judge and decide the law. On July 12, 1947, Judge Waring issued his decision in Elmore versus Rice, declaring the white primary unconstitutional. Judge Waring ended his order by stating, it is time for South Carolina to rejoin the Union and to adopt the American way of conducting elections. Judge Waring's order, both its substance and its tone, was then unprecedented for a Deep South federal judge. And its significance was immediately appreciated by the NAACP's leadership. Walter White, then the executive secretary of the NAACP and a close political ally of President Truman, had a copy of Judge Waring's order hand-delivered to the president, referring to it as, quote, an extraordinary decision by a Southern judge, end quote. William Hastie, later appointed the first black federal judge in American history, wrote Thurgood Marshall, Thurgood, I have read the South Carolina opinion 3 times, and I still don't believe it. In many respects, I think this is your greatest legal achievement. So at the time of the extraordinarily courageous judges on the Fifth Circuit, that would be later. Those were Eisenhower appointees. In 1947, when Judge Waring is issuing these decisions, he's out there all by himself. South Carolina party leaders attempted to evade the judge's order by adopting what they dubbed the loyalty oath, requiring African Americans seeking to vote to pledge their support to racial segregation. Judge Waring summoned all 93 members of the Democratic Party's executive committee, then the most powerful political leaders in the state, to his Charleston courtroom for an emergency hearing. He told the parties assembled that a federal judge faced with contempt could impose a fine or a jail sentence. He wanted those present to know that if there were any further violations of his order, there would be no fines. Think about that one. Judge Waring's threat to incarcerate party leaders who would interfere with the right of African Americans to vote broke the resistance, resulting in 35,000 African Americans participating in the 1948 primary election, compared to 3,500 African Americans voting in the Mississippi Democratic primary that same year. And this image is an image of a group of African American citizens being sworn in to vote, and the second person on your left is Mr. Elmore himself being sworn in. Judge Waring's decision declaring unlawful the state's primary and threat to jail white political leaders to uphold the voting rights of black citizens hit South Carolina's segregationists like a thunderbolt. Death threats, written and oral, were constant, and that ever-present cross burned in his yard. On the order of the United States Attorney General, Judge Waring was given 24-hour U.S. Marshal protection on the well-sourced information that there were attempts to assassinate him. Time magazine described Judge Waring as the man they loved to hate, but noted he was proving to be a person of cool courage. If the constant public attacks and threats on Judge Waring were designed to cower him, it did not work. He continued his study of race and justice in America and became convinced that the foundation of Jim Crow laws, the 1896 decision in Plessy v. Ferguson, was legally, historically, and morally wrong. Then approaching 70 years of age and likely retirement, Judge Waring resolved to play a role in overturning the separate but equal doctrine. Judge Waring was convinced that the United States Supreme Court would overturn Plessy if the proper case was presented to it. And many people have asked me, what gave him such confidence of that? And the answer was that although he was reviled in his state, native state of South Carolina, he was greatly admired in the federal judiciary and had personal relationships with justices on the Supreme Court. In other words, he had counted noses. Judge Waring had on his docket a case from Somerton, South Carolina, Briggs versus Elliott, which challenged the unequal school facilities and resources provided by the district's to the district's African American children. At the time, the NAACP was bringing what were known as Plessy cases, because the practice was not separate but equal. It was separate and unequal. And the NAACP was bringing lawsuits demonstrating that inequality without challenging segregation. They were winning those cases. But the problem was, every time you used Plessy to win a case, you were securing a bit more the inferior legal status of America's black citizens. And it was a controversial device. Judge Waring didn't like it. And I'm sure Judge Childs and I will talk about this a little bit. Judge Waring brings Thurgood Marshall into his office and basically says to him, I don't want to try any more Plessy cases. Bring me a frontal challenge to segregation. Every time I speak around the country, everybody wants to know about that ex parte communication. It was, okay? But it's a story, and you know, I'm glad to talk later about how I know this, but I basically resolved I was going to tell the story, and this is history. I'm not making commentary. I'm not endorsing the practice. I'm simply reporting the story. Judge Waring, when there was a status conference, pretrial conference, the Friday before that Monday trial in the separate but equal case, the Plessy case. And after having this conversation with Thurgood Marshall, the public was present, as were reporters, at the pretrial hearing. And Judge Waring asked Mr. Marshall, are you challenging the constitutionality of public school segregation? He says, I am. They dismissed the original lawsuit and refiled it as the first frontal challenge to public school segregation in American history. And the rest, as they say, was history. Judge Waring sat on a 3-judge panel that heard that case, and he dissented. He filed a dissent. And all the other cases involving that eventually were consolidated under the name Brown versus Board of Education, 14 different judges involved. Only Judge Waring took the position that segregation, that even if the schools were equal, it violated the 14th Amendment to mandate segregation. Now, when that trial came up in Charleston in May of 1951, it was very unusual for African Americans to come in large numbers to civil rights trials, lest they be identified as challengers to the racial status quo. If you were a school teacher in that area, you would be fired. But on that morning of that trial, as the sun rose in Charleston, African Americans lined up outside the federal courthouse and down Broad Street as far as the eye could see, believing they had come to watch the most important case in American history. In that line was a young African American law school graduate, not yet taken the bar, Matthew Perry, who Judge Childs mentioned as a heroic figure in South Carolina. He watched that trial. So here's an image. First of all, I've kind of popped here. This is an image of Thurgood Marshall arriving to try the case. That is the courthouse with African Americans lined up. And that beautiful image is by the great South Carolina artist Jonathan Green of the opening day of the trial of Briggs versus Elliott. And Judge Waring was asked in retirement, what did you think when you looked out of your window and saw that huge crowd? And he said, it was like looking at a breath of freedom. And that is the name of that beautiful painting. And by the way, the original is in our federal courthouse in Charleston. The largely African-American audience was not disappointed by the case presented by Thurgood Marshall, which included the groundbreaking doll study testimony of Dr. Kenneth Clark. That's the famous doll studies. And part of the trial was a searing and incredible cross-examination by Thurgood Marshall of the state's key witness, whose last name was Crow. You can't make it up, okay? The panel's majority ruled that South Carolina laws mandating public school segregation were permissible under Plessy. Judge Waring, fully aware he was writing a dissent for the ages, wrote an elegant and brilliant attack on the foundations of segregation in America. He concluded his dissent by stating segregation is per se inequality, and that segregation in education adopted in the state of South Carolina must go and go now. Judge Waring praised the plaintiffs, the Briggs plaintiffs, in his dissent, fully aware that they were suffering severe retaliation back home as a result of their participation in the case. He observed that the plaintiffs had, quote, shown unexampled courage in bringing and presenting this cause in the face of the long-established and age-old way of life which the state of South Carolina has adopted and practiced and lived in since, and as a result of the institution of human slavery. Soon after filing his dissent, Judge Waring, exhausted by the ostracism and death threats he faced in Charleston, retired and moved to New York City. The plaintiffs appealed the adverse three-judge panel in Briggs directly to the U.S. Supreme Court, making it the first of the four cases that would compose Brown versus Board of Education. On May 17, 1954, a unanimous Supreme Court issued its decision in Brown, casting aside the separate but equal doctrine and adopting the per se rule that all government-mandated segregation in public education was unconstitutional, first set forth by Judge Waring in his Briggs dissent. On the night of the Brown decision, the leadership of the NAACP traveled to Judge Waring's small Upper East Side apartment to toast the man they viewed as the father of Brown. And here's the cover sheet of the Brown decision. The second case down there is Briggs versus Elliott. One of those great debates in South Carolina is why wasn't it the first case? And that's another subject we might discuss, okay? Judge Waring was always philosophical about what he called the unpleasant repercussions of his civil rights decisions. In an oral history late in life, he stated, taking the whole thing in balance, I am enormously fortunate because you don't often in life have an opportunity to do something you really think is good. The other penalties don't amount to anything. They're offset by what I think is a really important contribution to the history of our country. Thank you.
Well, thank you all. And we thought we'd take a few moments just to have a little conversation, and then hopefully at the end, maybe a couple of questions from the audience. And so I want to thank my friend Judge Gergel for writing this book. It took him about 7 years to do so.
I'm slow.
Not at all, but I want to thank his wife more because many of her vacations were spent in libraries and other places around the nation. So this book is about Veterans Day, you know, essentially with the military service, role of federal judges in the civil rights movement, and of course, executive power, and of course, courage. So while you're on that 7-year tour, essentially, tell us about some of the challenges you found in terms of getting the documents, some of the testimony, and maybe what were some of your surprising and exciting finds?
Well, first of all, because I needed to give an abbreviated version, I didn't really give, a good part of the book is related to Harry Truman's role in desegregating the armed forces of the United States. And he is inspired by that conversation. In the White House, he's meeting with these African-American leaders, civil rights leaders, and he learns of the blinding of this, this battlefield decorated soldier, just set him on a course. And in the letter where he told the Attorney General about the blinding of Isaac Woodard, he also said, we have to do more than just prosecute. And he says, I'm going to appoint the first presidential commission on civil rights. He does that, and the primary recommendation of the commission is the desegregation of the armed forces of the United States, which is an incredibly important moment in American history because it desegregated the most admired institution in American life at that time, just shortly after World War II. And clearly inspired by the horror that Truman felt for the blinding of Isaac Woodard. And then the case comes before Judge Waring. He is deeply moved by the blinded soldier, and he writes this incredible dissent that becomes Brown versus Board of Education. So what was surprising was, out of this event, no one remembered the two most important moments in early American civil rights history were inspired. And that was a sort of remarkable kind of discovery that I made, that no one had really connected all of that into this, how significant this event really was. And then there was the issue about, how do I know that that Thurgood Marshall had an ex parte discussion? Yes. And that was, actually Judge Childs has a role in this discussion. So there was an oral history by a fellow named Alexander Rivera, who was a reporter for the Pittsburgh Courier, a major African-American newspaper of the day. And he was a great friend of Marshall's, Thurgood Marshall. They traveled together. He would cover the cases, but they were fraternity brothers. They were friends. They were close with each other. And when Thurgood Marshall came to the courthouse in Charleston that Friday for the pretrial conference, his buddy, Alexander Rivera, was with him. And when he arrives at the courthouse, the marshal says, Judge Waring wants to see you in chambers. And Alexander Rivera walked up there with him, waited outside, and he came out. Thurgood Marshall told him the story. So he was a source. And late in life, he was in an oral history interview, Duke University, oral history. And he says, I just need to tell this story. And he tells the story of the ex parte communication. He says, no one gives Judge Waring credit. He's the one who pushed Thurgood, okay? So I had this story of the most important case in American history, beginning with an ex parte communication, and I had one source. Not good enough, okay? So I had shared with Judge Childs this problem and my anxiety about it. And we were at a Federal Judges Association meeting, and there being honored was Nathaniel Jones, a former general counsel of the NAACP, later appointed by President Carter to the Sixth Circuit. And he was, I don't know, I guess Nate was like in his 90s then, right?
Yes.
And Judge Childs said, well, go talk to Nate. Maybe he knows something about this story. So I sat down with him and I said, Judge Jones, I'm working on this book about Judge Waring. And he says, are you doing a biography? I said, no, sir. He says, well, they need a biography. They need a good biography on Judge Waring. And I said, I'm interested in a conversation that if you ever heard about between Thurgood Marshall and Judge Waring. He said, yeah, I know all about that conversation. I said, really? He said, yeah, I was told that story. I said, who told you? He said, Walter White, who was the executive secretary of the NAACP and Thurgood Marshall's boss. He told him the story. I now had two sources, okay? So Judge Jones says, well, so you're doing this biography of Waring? I said, no, I'm doing it on an African-American soldier by the name of Isaac Woodard. He says, Isaac Woodard? I said, yes, sir. He said, I knew Isaac Woodard. I said, Judge Jones, how do you know Isaac Woodard? He said, well, I was working for a black newspaper when I came back from World War II. I hadn't gone to law school yet. And my boss came in my office one day and said, this blinded soldier is speaking at your church Sunday. Go cover the story. And I said, well, do you remember what he said? Oh, yeah, I went there and I was looking for this guy, and there was a guy in an army uniform with sunglasses. I figured he was my guy. And I sat down, and for 30 minutes, I interviewed him. And he said it was a remarkable story. And I identified with him because I was a veteran, and he was a veteran, and this was a horrible story. And so he told me what Isaac Woodard said at the thing, who introduced him. I said, how do you remember? This is like 70 years ago. And he said it was just such a profound moment for me when I heard this story. And I said, and he says, and I wrote an article about it. Okay, I wrote an article for the newspaper. So I was joking about going to the Library of Congress to do research. The Library of Congress has the NAACP papers, 4 million documents. It's an incredible, it's the largest collection in the Library of Congress. And it is lovingly curated, it's really well done. And there was an Isaac Woodard file. And in the file, every time somebody, one of these African-American newspapers would write an article about the case, and there were a lot of articles at the time, they would clip it and put it in this file. And I didn't have time to write everything down, so I had my cell phone and I would take pictures of it. So I'm sitting there with Judge Jones, I pull out my cell phone and I find his article from 1946. And it's exactly what he had just told me. And he was like flabbergasted. So Judge Child had not suggested go talk to him, I would have never done that. We also were concerned about how was Isaac Woodard blinded? And the police officer said he attacked me, right, in a southern town, a black man attacks the white police chief, right? He attacked me and I hit him one time, I don't know how he got blinded. Well, it didn't make sense to me medically. How could you be blinded in two eyes with one strike? It didn't make sense. And I was at dinner one night with my colleague and his wife, David Norton, my dear friend. And it so happens his wife is one of the nation's leading forensic pathologists. So I said to him, I said to her, Kim, can you imagine how this might happen? And we start describing the crushing of the eyes, and my wife says, y'all go sit at a different table. I can't, I'm trying to eat dinner. Okay. And so she says to me, I think it's very unlikely, but you need to get me an x-ray report or an interpretation of x-ray report, because there'd be certain findings. If it would be very unlikely it could happen, but there's a remote possibility, but it would have probably killed him. But there was you'd have to have fractures over both orbits of the eye. So luckily, and that's another whole story I won't tell, we've run down his record, and there are no fracture of the orbits. And Dr. Collins provided me a expert report that he was blinded in the way Isaac Woodard said it was blinded. We reconstructed something from 70 years earlier. All those were kind of interesting adventures in this book.
Well, so you're a federal judge. You actually work in the same courthouse where Judge Waring worked, and that courthouse has been renamed for him. But you were also a former civil rights lawyer. So just tell us about that in terms of how it informed your writing on Judge Waring, and just even your thoughts in now a role as a judge in hearing civil rights cases.
Well, the story of the naming of the courthouse is a remarkable story unto itself. Judge Childs participated with me in a program in 2011 called J. Watus Waring and the Dissent That Changed America. The Charleston lawyers were stunned that this judge they had long forgotten was this civil rights hero. And at the program, it was a packed room like this, was Fritz Hollings, the retired U.S. Senator, and for whom the courthouse was named. And so Fritz, I knew very well. He said to me, I never wanted to name the courthouse for me. It was done. I was out one evening. Strom Thurmond wanted to name a lake for himself, so he named the lake for himself and the courthouse for me. That's how it happened. And I never was happy. I wanted to name the courthouse for Judge Waring. And Fritz had actually been in the Briggs trial. He had been a lawyer for the state in that case. And he had great admiration for Judge Waring and his courage. And he says, I want to take my name off the courthouse and have it named for Judge Waring. Well, Congress does that. Judges don't do that. And I said that. He says, you don't think I know that? I said, but I want you to help me do it. Well, we didn't feel comfortable trying to take Senator Hollings' name off our courthouse. We had great respect for him. So, and his former law partner, Mike Duffy, was also in my courthouse, and he kept talking to Duffy and me about doing it, and we just weren't doing much. So one day, I said to Judge Duffy, every time I see Fritz, he asks me when I'm gonna do something about changing the name of the courthouse. He says, I'll tell you what, tell him to write you a letter. He won't write you a letter. And every time afterwards, tell him to write you a letter. I said, great. Next time I see him, he says it. I said, write me a letter. And the next day, a 3-page hand-delivered letter comes. And finally, I get a call from Jim Clyburn. He says, Fritz called me, and he wants to have his name taken from the courthouse. I said, well, he's been talking to me about that for 5 years. And Senator Graham called me. He says, Fritz wants to take his name off the courthouse. Ends up, no one has ever had their name come off a courthouse. That's just, And Fritz Hollings wasn't really known being a humble guy. His wife used to say that she and the senator were in love with the same man. But he did it. And it passed Congress, and President Obama signed it into law. And we honored Fritz at the ceremony, renaming of the courthouse, and then former Vice President Joe Biden came and delivered a talk honoring Fritz. They were great friends from the Senate. And then a few months later, Fritz passed away, and that was President Biden's eulogy, was the story of the changing the name of the courthouse. So we're very honored to go to work every day in the J. Watus Waring Federal Judicial Center.
So you've been on this book tour for now 5 years.
It's ridiculous.
I told him, no. It's wonderful because as we began at the beginning, it just goes into several topics that are always relevant today. And so he's been at the National Archives. He's been at the National Library of Congress. He's been on C-SPAN, PBS, and most recently interviewed by Justice Ketanji Jackson. But what I've learned in being on some of these book tours with you is that sprinklings within the audience, they end up resonating with this story and they tell you more.
Oh.
So can you share some of the things you've learned that's not in the book because you've only recently learned it after the book?
Yeah, we went to Batesburg where the blinding occurred. And the town was dedicating a historic marker, telling the truth about the blinding of Isaac Woodard, which I thought was a very noble thing to do because most towns cover up their unpleasant history. This was honored. And while we were there, There's a great historian, Bobby Donaldson, who is at the University of South Carolina and is a great keeper of the history of the civil rights movement. And he says, Richard, come over here. This woman saw the beating of Isaac Woodard. I said, what? I had not met anybody. I mean, and there was this very elderly African-American woman. I said, tell me the story. And she said, well, I was about 16 years old, and there was a black theater across a railroad track, and I was the ticket taker. And someone says they're beating a soldier over there, and I abandoned my job, ran across, and I saw him being beaten. Wow, that was pretty powerful story. Another occasion, I'm at the Truman Library speaking, and we're talking about the desegregation of the military, how important it was. And this very distinguished looking gentleman stands up, retired. He told us he was a retired 3-star general. And he says, I owe this to Harry Truman and Isaac Woodard. Okay, the commander at Fort Jackson gave a talk one time and said he wished he could bring Isaac Woodard back to show the army he had created. So these are, great stories. And I just, I keep going. Judge Childs knows this as well because she's like invited to speak everywhere, is that you can't pay a federal judge an honorarium. We're a cheap date.
And I want to open it up to the audience because we just got a few more moments to make sure that you get all your questions answered.
Yes, ma'am.
So, thank you, by the way, for coming to speak to us. So the role of judges in the civil rights movement is kind of ebbed and flowed over the years, most recently with the Supreme Court finding affirmative action programs in universities unconstitutional. So looking forward, what do you think the role of judges is going to be in this movement?
We never know where the future is, but I will tell you, without commenting on cases, I try not to comment on the highest court in our land, but I will say this. History shows that the pendulum swings one way and then swings another. Just wait long enough. It will change. But one of the reasons that Judge Child gives this wonderful talk about judicial courage, and I'm out talking about unexampled courage, is that we're talking to the next generation right here, right? The torch is being passed to y'all. So that next generation may be inspired by the people sitting in this very room.
Others?
Yes, sir.
Thank you for being here. Amongst this case and amongst other cases brought to as well in American history, would it be valid to infer that decision reads and develops constitutionality?
I'm going to say that last part again.
Would it be valid to infer that decision develops constitutionality?
Yeah, we know from the question is does dissension create these kind of constitutional issues? And from the very courageous folks who stood up in Soviet Union, the great dissenters, they created a whole a milieu of themselves of dissent and inspired action. The answer is yes. I think that and it's one thing to have judges doing this. It's got to come from the bottom up too. It took Isaac Woodard not to be insulted. He was treated very disrespectfully. He spoke back and says, speak to me like I'm a man. I'm a man just like you. That's his crime, okay? Just speak to me. I mean, this is a guy he's a sergeant. He's got battlefield. I mean, it's crazy, right? But so I think it definitely, the civil rights movement generated a body of law that's very important. Not just Brown, but a whole legion of cases, including the desegregation of this university. Yes, dissent and dissension and injustice helps develop the law.
There are a lot of think tanks. We were talking with some students earlier about just careers generally. A lot of think tanks out there, a lot of opportunities to actually represent the appropriate plaintiff in a case so that you know how to prevail and bring the right case so that the law does develop over time. It's incremental change, but it gets there.
Before the Oglethorpe case, the gay marriage case was issued by the Supreme Court. Judge Childs and I declared the South Carolina statute unconstitutional. Two different issues, but we basically did them the 1-2 punch and knocked it out. And, you know, that's one of today's civil rights movements, right? Yes, sir.
So, thank you again for the talk. I suppose it's a similar but slightly tangential question between the two. Have you found the appropriate flexibility in the law as it stands to make decisions based on what you feel is right?
In almost every instance, and I'll let Judge Childs, there are times that an unjust result does occur. I try not to make it at my hand. Somebody else might do it, but not me. I feel a great freedom to do what I think is right, and I'm not worried if somebody wants to reverse me. That's somebody else's business, but I'm going to do what I think is just. Maybe one of the best decisions I ever read was the immunity decision written by the 3-judge DC panel in which Judge Childs sat. That is a great decision. It did not prevail, but one day it may prevail. So yes, the law, you know, it was a great statement Dr. King used to say, the arm of the universe is long, but it bends towards justice. Because you know, sometimes it doesn't always come out in the short term that way, but I have a great confidence that in the long term it will.
And I would just add that as a former trial judge and as a trial judge, we develop the record essentially, you know, based on what the parties present to us. And it's very important on how we use our discretion and how we see the record and how we get the case to the jury. Even as far as jury charges, you know, you cannot think that the trial is over. Those jury charges are so important in how the juries will see the facts in any particular case. So you have to see it through and make sure that we're doing the appropriate things so that the jury has everything that they need for them to make the decision as well.
The answer is yes, there is great flexibility. And creative lawyering is very important, okay? That's why you're getting all these great skills here, so you can use it as a tool for justice. Thank y'all very much.
Thank you so much.
So Judge Childs, Judge Gergel, Ms. Gergel, thank you so much for joining us. I was struck by the entire book and your testimony on the courage of judges, whether it's judicial courage or unexampled. It seems to me in your remarks, Judge Childs, that there's some unexampled courage there as well. I was struck by the final, almost like an epilogue in your book, whereby the unjust charges, criminal conviction really of Isaac Woodard. For public drunkenness. So clearly a misjustice was only overturned in 2018 after, and I think this is care of your book. So that charge and that conviction takes place in the mid-40s, and an entire adult lifespan before those charges are dismissed and reversed. And it just serves to remind me that, and I see it in your example with some of the cases that we've mentioned here in your own work, that these injustices and racial justice just generally, in the case of Isaac Woodard specifically, the courage of President Truman and the judges that you mentioned, Judge Childs, these incremental progress or 2 steps forward, 1 step back, it doesn't happen because of a kind of natural logic that people come to, or a quiet condemnation, or some kind of quiet contemplation, and it just changes. It requires courage, which you've discussed today. It requires persistence and a kind of doggedness that may take decades. Thank you for your research. Thank you for your jurisprudence, both of you, and for joining us today. And I ask you to join me in thanking them.